The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
I'm Vinnie Politan. The subject of my investigation is the trial of Karen Reed, a college professor accused of murdering her Boston police officer boyfriend, John O'Keefe. It was a story that divided a community and had the nation riveted as the trial played out right here on Court TV. While the case is far from over, with many questions still left unanswered, here's the story.
It was the biggest, most divisive trial of 2024. Karen Reed accused of murdering her boyfriend, Boston police officer John O'Keefe. Prosecutors say she ran him over in a jealous, alcohol-fueled rage and charged her with murder. But the defense painted a different picture, a police cover-up spearheaded by the lead investigator, Trooper Michael Proctor, who they say framed Karen Reed for murder. The case divided the community and created a very intense situation at the courthouse. Karen Reed supporters dressed in pink, while those who supported the police wore blue. The same divide existed inside the jury room, as the case ended with a deadlock jury in the 3-count indictment. But after the trial, the defense says 5 jurors came forward to say they actually unanimously agreed Karen Reed was not guilty on counts 1 and 3. But the judge denied the defense request to bring the jurors back to court to find out if they actually reached verdicts on those 2 counts. And now the Massachusetts Supreme Court is hearing the case as the defense tries to get 2 of those counts dismissed.
So much drama throughout this case, and now in front of the Massachusetts Supreme Court because of what happened with this jury at the end. And it comes down to, did the jury find Karen Reed, agree that she was not guilty of counts 1 and 3, which is the top count, murder and leaving the scene of an accident? So there was argument in front of the Supreme Court justices, and there was a discussion about exactly how it all went down. Like, how was it that all of a sudden the verdict or the note was handed in, and all of a sudden there was a mistrial and the jury's gone and the defense is wondering what happened. So I want you to take a listen to the back and forth in front of the Supreme Court. The attorney you're listening to is the appellate attorney for Karen Reed.
They had no opportunity at the time.
First note, was there an argument made concerning ambiguity in response to the first note reporting impasse?
No, there was a request.
Was there any
for
ambiguity argument made in response to the second note?
There was a request for TUI. But the only time that I suggest matters is the third note, where they had no opportunity to make that argument.
Why would that be? Why would we just focus not on the totality of the 3 notes, but just the last note? Why is that, in your opinion, or actually citing any legal authority, why would that be the critical moment?
Because before that, there's at least an impasse on 1 count, and there is no obligation on a trial court in terms of timing when to seek a partial verdict. When Judge Descasiano asked me for what the 3 alternatives are, one of the alternatives was simply to ask the jury what it meant. The second was to apply Rule 27B, which says before a mistrial, a court may request of a jury whether or not they've reached any decision on any of the other counts.
The third time, it sounds like that everybody's in an impasse. That's all the information she has.
And that's part of the perils of not providing counsel with an opportunity to be heard, which is what was required.
So something that's happening in all this is that the justices and prosecutors as well are saying, listen, the defense attorneys didn't ask for this jury to be polled. They did not interject. They didn't object as all this was happening, which brings us to our first question of our investigation, which is, did the defense have time to do anything? Did the defense have time to make an objection? Did they have time to interject? Was everything moving too quickly, or did these defense attorneys drop the ball inside the courtroom at the moment that the mistrial was declared? Joining me to get to the bottom of it, we've got some great local insiders, criminal defense attorney, college instructor, and author Peter Ellikin, and he served as special trial counsel to Johnny Depp in his defamation case, trial attorney Wayne Dennison. Great to see you both tonight on this. So what I want to do, because there's this argument about this moment when the third note comes out and how it all goes down and why didn't the defense do something. So let's take a look at how it actually went down, and then I want to hear what you two have to say. Let's take a look.
Thank you. Be seated. Closing session.
22-117 Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
Rise to the jury. Close the session, please be seated.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case.
Okay, there you have it. Peter Ellikin, Wayne Dennison, as we look at what happened here, I'll put it up on the screen. And so we can answer the question whether or not the defense had time to do anything here. From the time the judge announced an impasse to when the jury entered the courtroom was 30 seconds. Okay, 30 seconds pass. From the time that the jury enters the courtroom to the judge begins reading the note, another 38 seconds passes. And from the time the judge reads the note out loud to declaring a mistrial is 49 seconds. Peter Ellikin, you've tried hundreds of cases. Was there enough time here for the defense attorneys to do something?
Probably not, because she didn't even say ready to, she didn't give anybody an opportunity to talk. She didn't. Normally the defense counsel, the prosecution would weigh in on what do you want to do, what do you want to do now, the judge would ask. And nobody was asked those things. And so simply she said, you're in an impasse, you're dismissed, and that was it. So again, but the question is, could somebody have leaped up and yelled or something? No, we want to be heard. And I guess maybe that's the issue here. And
well, does that happen, Peter? Do defense attorneys jump up and yell? I think I've seen it once or twice.
It's happened, I think, in the realm of possibility here. One of the things that is really confusing here, though, I can't wrap my head around, is that, again, I truly believe that they were deadlocked. That they declared not guilty on both counts. I mean, these fine lawyers are not going to lie. Enough of them came forward afterwards. But why wouldn't they have given any indication? I don't think any of the lawyers had any idea. All they ever heard was that they couldn't come to a decision. And so the thing I can't wrap my head around is if they couldn't come to a decision, couldn't they have at least said, because it was
But everyone makes mistakes. Everyone makes mistakes.
We're deadlocked on the other.
Right. Well, here's what happens in courtrooms, though. Judges make mistakes. They get appealed. It does not impact a criminal defendant, right? Lawyers can make a mistake in a case, and it doesn't negatively impact a defendant. But here, a jury potentially made a mistake, and it's looking like it's impacting this defendant to a certain extent. Wayne Dennison, was there enough time here? Was there enough time for the defense to jump up and do something? We just saw the way it went down.
Yes, there was enough time, and you provided a timeline that was really interesting, but that's not the timeline we should look at, because they knew for days that there was a real possibility of a hung jury here. They'd been grieving over this issue for days. So it's not as if this notion came out of the blue. They had made even a previous motion for mistrial. So at this point, it's not as if that this is a new idea. And quite frankly, even if the judge says, hey, we're done, we're discharging you from your duty as a juror, you can jump up and say, Judge, hold on a second. And quite frankly, I don't know a judge who would say no to that.
Peter, the way things were flowing there, would you have jumped up?
Yeah, I might have been a little confused because in all the times that the jury gave messages here, they never mentioned that they were only deadlocked on one of the issues. So I wouldn't have had any tip-off point. In retrospect, it probably.
Well, would you jump up and say, "Listen, Judge, can we question this jury about whether or not they're deadlocked on all three charges?"
Yeah, that would. I don't think there was any indication of that. I don't think they had any tip-off. That was an issue. Maybe they overlooked it. The prosecution, it's their case. They didn't get up and ask that either. And the judge didn't ask it either. And again, under law here, the judge is not required to do that. A lot of judges would poll the jury and ask them, all right, which charges are you deadlocked on or not? And a number of judges, another judge might have done it, but under the law, the judge is not required to do that. Maybe this is a lesson for judges in the future as a best practice going forward, that maybe they should ask that. So I guess none of the three asked that. But then, is this such a violation of the rights of the defendant here that I wonder if this is the biggest issue, that the fact that we now know that they were that they
they're claiming double jeopardy, violation of the Fifth Amendment of the Constitution of the United States of America. Hold your thoughts. We've got more to get to here. Coming up next, why doesn't the prosecution want to know if the jury reached a verdict?
At most, what we're talking about here with these juror statements is a snapshot of the jurors' deliberations.
Now, back to the Court TV podcast.
I'm not from Texas, like my colleague here. I'm a Boston kid, but I'll repeat what he said, which is, we ain't got no quit.
That's Dave Yannetti, one of the attorneys for Karen Reed. She now has an appellate attorney who appeared in front of the Massachusetts Supreme Court. And what Karen Reed and her team is trying to do is get the Supreme Court to tell the trial judge, Judge Cannoni, to bring the jury back and ask them if they reached a unanimous verdict on counts 1 and 3, because 4 to 5 jurors have come forward to the defense saying that they did in fact find her not guilty of counts 1 and 3. So I want to play for you the appellate attorney for the prosecution who was arguing in front of that same Supreme Court. Take a listen.
At most, what we're talking about here with these juror statements is a snapshot of the jurors' deliberations, but you cannot short-circuit the verdict requirement and rely merely on such a snapshot. And it's important because it protects defendants too. You could imagine a different scenario where a juror comes forward and says, notwithstanding the declaration of a mistrial, we all took a vote and we found the defendant guilty of murder. If the Commonwealth were to come forward and say, effect should be given to that vote, there can't be any serious doubt that the defendant, whether in this case or in a future case, would argue that is not a valid verdict and shouldn't be given any consideration.
Interesting argument by the prosecutor there, probably pretty valid, although the state doesn't have a double jeopardy issue or the constitutional protection of the Fifth Amendment. Which brings me to my next question, because the prosecution doesn't want the jury brought back. So why doesn't the prosecution want to know if the jury reached a verdict? Why don't they want to know? Still with me, Peter Ellikin, Wayne Dennison, great attorneys, trial attorneys. I want to play one more little piece of the argument from the Supreme Court, which again talks about this issue about what really happened in that jury room as to counts 1 and 3. Take a listen.
He says we should expand our law, as I understand him, to include the Fifth Amendment right and double jeopardy protections as well. What's your response to that? Why not?
I agree with the reasoning of the appeals court in Di Benedetto that it can't simply be the fact that it implicates a core constitutional right to allow for this sort of inquiry. And here, unlike...
Why not? Why is the Fifth Amendment any lesser of a right than the Sixth?
It's not that it's any lesser of a right, Your Honor, but although it is different than the Sixth in that here there's, a balance of two competing public policy considerations. It's not simply the defendant's right, there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Well, doesn't the public have an interest in finding out the truth of what the jury decided?
The truth. Wayne Dennison. Isn't that ultimately like the purpose of our system of justice, to get to the truth? Like whether it's the truth of what happened, who's responsible, or whether or not a jury agrees to a verdict? Why doesn't the prosecution want to know the answer to the question of whether or not this jury reached a verdict?
I think there's probably two reasons. One of which is in every single trial you ever do, and I'm actually trying a case right now in that same courthouse, every day the judge says you cannot, as a juror, deal with any outside influences. You can't talk to anybody, you can't hear from anybody, you literally can't go on the internet. And what happened here is you've released these people, quite frankly, into the wild on one of the most watched cases ever. And they will invariably have now gotten outside pressure. That's one issue. The second issue is the murder charge, quite frankly, is the only real bargaining chip that the prosecution actually has to see if they can ultimately get a plea deal here. Because that's the charge that's the scariest charge. And if that goes away, the likelihood of a plea, I think, goes to zero.
So they're not necessarily interested in the truth, is what you're telling me. Peter Ellikin, why from your perspective, why do you think the prosecution wants to know if the jury reached a verdict?
Well, the prosecution remember, the defense is supposed to be an advocate for their client, but prosecution is supposed to be in favor of justice. Why wouldn't they nail this down and get this clarified? And there is precedent for bringing back jurors. They just recently did that with another local high-profile Boston case, the Boston Marathon case. They had to bring some jurors back. I don't know if it was a couple of years later or something. So they can do that. I don't see any kind of there's one thing that I haven't quite understood about the prosecution here is that they must have something in mind, but I don't see any plea deal ever happening in this case. And therefore, if I was a prosecutor, I think I would, knowing it's going to go to trial, I'd want to get rid of my weak charges. That was always the weakest, the murder that they never even introduced any evidence at trial that she definitely intentionally killed him. So why wouldn't you want to get rid of that? And the manslaughter charge is the stronger charge, and that's the one I would be pushing. So I don't know about that, but I think that there is precedent for bringing jurors back, and I think it would really be nice to know one way or another, let's nail this down. Did they, in fact, factually all agree not guilty on the 2 counts?
Yeah, there's been a lot of protection of this jury, and I understand why. This is a very divisive and heated sort of case, but there's a lot of cases like that, Wayne. Isn't there a way to bring the jury in, ask them a very focused question, and isn't it simple? Did you reach a unanimous verdict on count 1? Did you reach a unanimous verdict on count 2? Just answer yes or no, don't tell me anything else. And if you do that 12 times, and if you come back with 12 consistent answers, you kind of get an answer to the question pretty easily without interfering or delving into the process of the deliberations.
I think you could do that. And quite frankly, you're going to get jurors who are going to have to be sworn to tell the truth. You're going to presume they're going to tell the truth. And if you ask them very narrow questions, I think you would, in fact, get an answer.
Yeah, and we saw this in another case pretty recently, and I think it was in the beginning of this year, Peter Elkin, in the Murdoch case down in South Carolina. They brought back the jurors because of alleged interference by the court clerk. A judge questioned the jurors in court. They were sworn in. Their faces weren't shown. They were not revealed as to who they were. Only the ones who wanted to come forward came forward. And the judge got an answer. It just seems Massachusetts is very overprotective of anything related to the jury. Like nothing. Like nobody goes near a juror ever.
Oh, right. And in this case, it has worked out well. None of the jurors' identities have been revealed. The media was not informed of who they were. Everybody seems to be protecting them. So there are probably ways that they could poll the jurors, even get them to sign affidavits that the court could have control over, or bring them in. I don't know that has to be
bring them in chambers in camera.
They can do it in chambers, so we can keep their privacy intact.
Absolutely.
And we don't have to reveal, because there's good reasons why.
We are out of time. Thank you, gentlemen. I'm Vinnie Politan. We'll keep digging for answers as the investigation continues. I'm Vinnie Politan. We continue our investigation of the trial of Karen Reed for the murder of her boyfriend, Officer John O'Keefe. Two different stories were told in that courtroom during the trial, and it's still today unclear what really happened the night John O'Keefe died. Here's the story.
They show up wearing pink, some of them holding signs. They line the streets cheering on a woman named Karen Reed. She's not a celebrity. She's not a war hero. She's a college professor accused of murdering a Boston police officer named John O'Keefe. John and Karen were a couple who were practically living together. On the night of January 28th, going into the early morning hours of the 29th, they were out together. First at C.F. McCarthy's in downtown Canton, Massachusetts, then at the Waterfall Bar and Grill, and finally inside Karen's SUV in front of Brian Albert's house, who was having an after party with a bunch of the folks who were at the Waterfall. The big question is, what happened to John O'Keefe after he stepped out of Karen's car? Did Karen run him over, or was he killed by someone at the party? The jury couldn't figure it out, so a mistrial was declared, and now a new trial has been scheduled, and Karen Reed is speaking out about her case and about what happened that night.
What a case, what a story, what a trial. So as we wait for the Massachusetts Supreme Court to make their decision, we wait for the retrial to begin, Karen Reed has spoken out and spoken to Vanity Fair. A reporter with Vanity Fair was basically embedded with Karen Reed for several days and wrote this really interesting article. So what I want to do for you right now is show you an excerpt from that article from Vanity Fair as read by our producers.
Beyond a bar run in the week before O'Keefe died, he had never really socialized with Albert, even though both were BPD, living in Canton, and had McCabe in common. Albert had an alluring reputation. He helped unmask the Boston Strangler in 2013 and capture the Craigslist killer before that. The night he died, O'Keefe was eager to join up for a nightcap. When he and Reed arrived at 34 Fairview, though, she wondered whether they were at the right address. There weren't many cars in the driveway, and Reed felt uneasy. McCabe had conveyed the invitation, So Reed wasn't sure how welcome the couple actually were. O'Keefe said he'd check out the scene and report back. But minutes passed without a word.
I got pissed,
Reed tells me now. She knew that a woman O'Keefe used to hook up with lived a few houses down the street.
He's got to be screwing around,
she thought.
I didn't think he was physically incapacitated.
After about 10 minutes of waiting, Reed drove to O'Keefe's house.
Now, she didn't testify at the trial, but that's her story to Vanity Fair about what happened that night. Which brings me to my next question in our investigation. Does Karen Reed's story make sense? Does it jive with the evidence that we saw over the course of months during the trial? Does this story of Karen Reed's, as she told Vanity Fair, does it make sense? Joining me, criminal defense attorney Peter Ellikin and the creator behind the Yellow Cottage Tales YouTube channel, Kevin Lenahan. Great to see you both. Thank you so much. Kevin, I'll begin with you. As you listened to that story, read the story, Karen Reed's version, big picture, does it make sense to you?
Well, I don't know why she'd be wondering whether he was incapacitated when she got home or when she woke up from the nap. It seems very strange to me that she would ever have that thought. I mean, as far as she should know, he should be either drinking at the after-hours party still, or maybe if she's suspicious, thinks he hooked up. But the other thing is, this article might have made sense a year ago to at least entertain it. But we've had the information from the trial, and the GPS shows, without a doubt, that John's phone did not go in the house. Yet it was found underneath his body at the far edge of the property, which is 80 feet from the driveway. And Karen tells us inexplicably that she watched him walk across the threshold into the house. So how did the phone get to the far edge of the property? And that phone stopped, it moved for the last time at 12:32 and 16 seconds. So not very long after John allegedly would have walked into the house. So there's just so many other aspects of this. This article felt to me like it was written by Karen Reed.
Yeah, well, she's embedded and I guess trying to get Karen Reed's story. So let's do this. Let's take a listen, though, because part of the story is that she was waiting for John O'Keefe and she got angry. So let's take a listen, Peter Ellikin, to some of the voicemails that Karen Reed left for John O'Keefe that night.
Now, as far as this first voicemail, what time did this occur?
12:37 a.m.
And with the court's permission, if I could play that for the jury.
Yes.
Third message, what time is that received?
12:59.
John, I'm telling you, kid. Nobody knows what the you want her.
With regard to the fifth message, what time was that received by Mr. O'Keefe's phone?
1:11 a.m.
Yes, 1 in the morning. I'm with your niece and nephew. You her. You're her.
And the sixth message, sir, what time was that received by Mr. O'Keefe's phone?
1:18 a.m.
John, I'm going home. I cannot babysit your niece. I need to go home. You are using me right now. You're another girl. He's sleeping next to me. You're a loser.
The seventh message, sir, what time was that received by Mr. O'Keefe's phone?
5:23 a.m.
Peter Ellikin, as we listen to those voice messages, is that kind of in sync with what she's telling Vanity Fair about her being angry?
Yeah, actually, I think, some people would listen to that and say, oh, that puts her in a bad light. She's using expletives. She seems really angry. If anything, if she knew that she killed him, why would she be doing message and increasingly angry? Where are you? Why aren't you getting back to me? I'm getting angry with you, on and on. That sounds like somebody who is not aware that he is, that he's dying somewhere. So I think if anything, that would exonerate her. I think, when you look at all the evidence in this case, and I'm not going to go through the long laundry list. I've never seen anything with so many moving parts in it. But we never saw a smoking gun on this case, did we? Like, oh, this got it nailed, or this absolutely exonerated her, or this nailed her, dead to rights, and she's guilty. We have a lot of little pieces of things, but I think that's one of the reasons why they couldn't convict. That there was she was either found not guilty on 2 of the counts, and they couldn't come to an agreement on the other, or if they were deadlocked on all 3. But I think there's a reason for that the evidence just wasn't there to convict.
Let's take a listen to something else, Kevin. I want to play this. This is the testimony of Brian Higgins, who's at the bar before the after party. He also goes to the after party, and we know that there's a little bit of a history between Karen Reed and Brian Higgins. Let's watch.
But she did not greet you, did she?
I think they kind of went like that in different directions.
Right.
Yes.
Did she greet you?
No.
Right. So she walked over toward the corner of the bar, and John came over and greeted you, and then walked over and joined her, correct?
Yes.
Karen didn't stop what she was doing once she was over in the corner of the bar and come over and say hi to you?
I didn't have any interaction with her that night, no.
So safe to say that throughout that evening, once she was sidled up next to John O'Keefe or friends that she was with, she never turned back around and came over and even acknowledged you, correct?
That's correct.
So she basically ignored you the entire evening?
That's not how I interpret it, no.
I didn't ask you how you interpreted it. I asked you what she did. Did she ignore you or did she pay attention to you?
Objection.
You can go ahead and answer that. Did she ignore you?
No.
All right, this is some of the video from inside the Waterfall Bar and Grill. Kevin Lenahan, do you think this is in sync with her not wanting to perhaps go inside the house at the after party because it might be a little uncomfortable after what happened between her and Brian Higgins?
Sure, you can start to loosely patch it together, and it looks like potentially Higgins felt a little bit jilted at this point and was interested in her, and that would have made her uncomfortable. Of course, in her Dateline interview that was aired a couple of weeks ago, she made it seem like she was waiting for John to say, hey, it's okay, come on in, which doesn't really make sense. In fact, in that interview, she said that she texted John to see if it was okay and called him. But the phone records show that that's not true. She didn't text him until closer to 1 o'clock, about 15 minutes after she got home. And the first phone call was at 12:33, where she got home at 12:36. She was almost certainly on the road at that time. So the story is ever changing, but you can kind of try to piece together something, I guess, that can look like someone else had a motive to kill him. But the simple fact is that data shows and the physical pieces show that matches it perfectly to her car. And I don't think there's going to be a way to get around it if the prosecution puts that together better in the second trial. The very evidence that they have, they just have to present it better.
Now, the other thing from the Vanity Fair article seems to be there's a theme of jealousy, that she thinks that John O'Keefe maybe is hooking up with one of his exes at the after party or in one of the houses in the neighborhood. And that came out through the testimony of Jen McCabe, who was driving with Karen Reed that following morning to look for John. Let's take a listen to that testimony again.
She just continuously screamed that. And then as we got by different landmarks, she then started, screaming, asking if John could be at certain people's houses.
And whose houses was she asking if John could be at?
If she could be at house.
Referring to the directions that you had provided the night before?
Correct.
And so that would have been, was a child who was around the age of and your daughter, correct?
Yes.
And there have been some years in the past dating relationship between Mr. O'Keefe and correct?
Yes.
And so Ms. Reed is saying that in the car that morning as you're driving over to Fairview?
Yes, she asked, could he have been with Ashley? And I looked at her and said no, because to me that was a crazy idea.
Okay, Peter Elkin, the jealousy aspect here. I mean, I think there's two ways this could go. It could explain her anger and why she drove away without John from her perspective, and he's in the party, she's afraid of that. But it also could kind of leak into a reason to get mad and maybe hit him with the car.
Yeah, we could just read this anyway. It just doesn't seem to really be clear cut. Again, I go back to the thing is, why is she asking people hours later, could he be here? Could he be there? Why would she, if she knew she killed him, why would she, why would she just be, giving him like 100 different messages and getting angrier and angrier? Why isn't she getting back to him? So, I think there's just so many ways to look at this, but that could be looked at a way to, in her favor again, that she's saying to everybody, where is he? Could he be here? Could he be
there? John? Exactly. All right, stay where you are. We know the first trial was huge, but still to come. Will the retrial be even bigger.
In the town of Canton, we have been subjected to domestic terrorism right here in the United States of America.
This is the Court TV Podcast.
Karen Reed was framed, and the world knows it. And anyone who looks at the scientific evidence, by the way, that came from people that are hired by the Department of Justice and the FBI, and guess what? The United States military. If there is someone on that jury that denies that irrefutable evidence, we got a problem. We have lost relationships with people we love because we chose to speak the truth and stand for an innocent woman that was framed. Our loved ones have lost relationships with people they love because we stood for truth. It ripples through the community. In the town of Canton, we have been subjected to domestic terrorism right here in the United States of America. Let that sink in. Let that sink in. We will not be terrorized anymore. No more.
I was in the middle of it all. The passion was real in the streets of Dedham, Massachusetts, and it began before the trial began. But once I got up there while the trial was happening, wow. And then people started showing up supporting the police on the other side, and you had a large amount of pink, and then you had amounts of blue that started to grow a little bit. For those of you who don't remember, take a look.
Folks, this is what it looks like when you bring false charges against an innocent person. The Commonwealth did their worst. They brought the weight of the state based on spurious charges, based on compromised investigation and investigators, and compromised witnesses. This is what it looks like. And guess what? They failed. They failed miserably, and they'll continue to fail.
These circus animals went down there to harass the O'Keefe family. Have some respect. A man has died. He has lost his life, and those children lost 3 adults that took care of them.
I believe that she's been framed.
I know what that blue line is all about, and I love that blue line, and I'm very, very proud of them. And I can't believe that they took their friend and put him in the snow.
Because this isn't normal to even be out here in the first place. I stream it every day. I stream it every day, but it really bothered me that they won't leave the O'Keefe family alone.
That's why we're here, because they harass it, letting the majority win. We are done letting the majority win. You stand for the right thing, even if you stand alone. Even if you stand for the O'Keefe family, we stand for John O'Keefe. This is an abomination what's happening. They're treating this like it's a recreation.
Like it's murder trial. Like it's all fun.
I'm not from Texas, like my colleague here. I'm a Boston kid, but I'll repeat what he said, which is, we ain't got no quit.
It was a trial unlike any other, but there's going to be another one, which brings me to my next question. Will the retrial be even bigger? Still with us, criminal defense attorney Peter Ellikin and YouTuber Kevin Lenahan, Yellow Cottage Tales. Kevin, the energy, the passion obviously was real in the streets. It started to grow on the other side. So as we're getting ready for another trial, from your perspective, is the energy, the passion still there? Does it still exist? Has it dissipated?
Absolutely, and it looks like there's going to be new evidence. So, and also both sides have motioned to postpone the trial until April. There's going to be a lot of new experts that are going to testify for the prosecution. The big new evidence is they should have been able to get GPS from the car, and they weren't able to because the entertainment system's software hadn't updated. That software seems to have finally taken place, and now they're trying to schedule to get that chip-off done. They'll know exactly where that car went with timestamps. So that could really change a lot of what happens here. But I also think we're going to get from experts a better explanation from the prosecution to explain John's injuries, which do, understandably, to people in the public seem strange. Like, how do you explain how his lack of other injuries besides what happened on his arm and stuff like that? So I think some of the passions are justified by what looks like odd things. But most of these odd things eventually have explanations. Most of them came out in the trial. But we do
you expect what we see here to happen again? Do you expect this to happen again? Or have people sort of forgotten about this and moved on?
Oh, no, it's only going to be bigger.
Only bigger. Okay. Peter Elkin, let me ask you, generally speaking, I come from the school of thought that a retrial, it's always advantage prosecution. There are some issues with some of the witnesses who testified for the Commonwealth in the first case. What do you think about this retrial? Is it traditional advantage prosecution?
I wouldn't say so. I think it's going to be a very different trial. First of all, I think that they're probably going to be there's an extraordinarily good prosecutor now in the case who got brought in, Hank Brennan. I suspect it's going to be a little more succinct, that they're not going to have 80 witnesses and anybody and everybody talking about various things that maybe aren't that important. They'll probably be like a bullet, get into the important things. We'll see what new evidence comes up. For example, the checking out the car was just mentioned. The prosecution doesn't know whether that'll help them or hurt them. So this will all be revealed. So at this point, I can't say any advantage whatsoever, other than the prosecution's still going to be stuck with some of the horrible, horrendous witnesses they had who got caught in all kinds of, I don't have to go into the list of it, but all kinds of misbehavior and poor conduct and have been suspended and all that. And you can't get away from that at all. As far as outside the building, I think the passion is going to be, I've never seen any case in all the decades I've been doing criminal law in Massachusetts that had higher passion going on. I mean, we've had bigger cases, like, for example, I just mentioned the marathon bomber case where all those people got killed and maimed and all that. That was different. That wasn't controversial. Everybody hated the, defendant from bad, and nobody debated any facts. We all knew he was guilty, and that was different. This one, though,
this is Sacco and Vanzetti. This is Sacco and Vanzetti, same courthouse, just, I don't know, 100 years later, 120 years later. Let me ask you, Kevin, people took this very personally. It became very personal, all the arguments. We have about 20 seconds here. Is that feeling still there, that people feel like they have a personal stake in the outcome of this trial?
Absolutely, and that's something that's going to have to be studied. Is why did this case resonate so deeply with people? Is it the odd things? Is it something about the defendant? Is it the idea of police corruption or power and cover-ups? All of those things are factors. And then finally, the social media and a defense team and the willingness to use bloggers and stuff like that. That's all a huge factor in here too.
All right, Kevin Lenahan, Yellow Cottage Tales. Great to see you, Peter Elkin. Always fighting the good fight. Appreciate it. It's frustrating for everyone involved when a jury is unable to reach a verdict. No one really wants to do the trial again, but it looks like that's exactly what's going to happen in Massachusetts in 2025. Now, generally, like I said, prosecutors have the advantage at a retrial. This case is different. Prosecution witnesses have had major issues since the trial, which may severely impact their credibility. But it will be a brand new jury, so you never know. You're going to have to watch it on Court TV. I'm Vinnie Politan. We'll keep digging for the answers as the investigation continues.
There you have it. If you want to see more in-depth reporting on the latest true crime stories, you can see me every weeknight, 8 p.m. Eastern on Closing Arguments. Thank you so much for downloading. And as always, please don't forget to hug the kids.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.